Well, what we're going to talk about today, obviously we're a special needs law firm, so we're going to focus on special needs areas. But this also applies to, irrevocable trusts that child or a family member have inherited management of. So it will touch on all bases of trust. But our goal is to review the basics of governmental benefits.
Well, they're sharing their screen and going over.
We're going to explore the relationship between these government benefits. We're going to understand trustee responsibilities, and we're going to discuss trust administration, including, the use of care managers to ensure quality of life. So trustee responsibilities, here's a typical situation where, mom passed away and now I'm taking over management of the trust. Maybe she told me about the trust, maybe she didn't. But the first thing that you need to do is take a look at the document, read the document from beginning to end. You might not understand it all, but that's why you should meet with an attorney then, read the document. It'll get you to square one at least. Then trustee responsibilities, you have fiduciary obligations. You are considered by Ohio law a fiduciary. You have responsibilities to the trust, to the beneficiaries, to other trustees, and to carry out what the settlor, the creator of the trust, wanted you to do. You have financial responsibilities. You have to invest the property, the money, the real estate, whatever that has come into the trust. You have investing responsibilities. You have to make disbursements according to the trust to the beneficiaries. You have to keep good record keeping of those disbursements, of the assets and money that are coming in. And you might have reporting responsibilities and the trust might have taxes to pay just like any person pays taxes on income, so does a trust. The trust might also have advocacy provisions. I know for Hickman and Louder trusts, for our disability trusts, we put advocacy language in there that the trustee might be responsible for, or the trustee might hire someone for those advocacy provisions. And if you represent or you have a skill or expertise, that raises the bar for those fiduciary responsibilities. So if son inherited this trust and he's also a CPA, well, he's got this skill or expertise that the normal trustee might not have, so that he kind of has this heightened fiduciary obligation.
Good morning, everyone. My name is George. As far as the fiduciary duties of the trustee, one of the most important things to keep in mind is that the trust is for the benefit of the beneficiary. So one of the important things to keep in mind is there is no self-dealing with the trust. So you can't borrow money from the trust for yourself. You can't invest the trust money in your own business. You can't buy or sell things from the trust, and you can't commingle the assets of the trust with your own assets. So everything needs to be kept separate, separate bank accounts, separate ownership of all of the resources. Now, keep in mind, these are the default rules, and there may be situations where the trust itself may allow some amount of self-dealing, but that's something that is for specific situations, and you want to get the advice of an attorney before you do anything like that. Now, you have responsibility as trustee for the trust ultimately, but you don't have to do it all yourself. You do have the ability to delegate. So if there are multiple trustees of the trust, you can assign different trustees to have different responsibilities. So one may handle the financial aspects, another may handle the record keeping, another may handle that care and advocacy portion, another may handle the public benefits aspect. And you can also delegate to professionals. So if you're the trustee of a trust, you can hire a CPA to help you. You can hire an attorney to advise about public benefits. The important thing to remember is you are acting in a fiduciary capacity. So you have that responsibility. And if you don't exercise that responsibility in an appropriate manner, you can be held personally liable. So if you need tax advice, get professional tax advice. If you're unsure about a care situation for your beneficiary, contact a care manager. Get in touch with somebody who understands, because ultimately to say that, well, I didn't know what I was doing isn't really an excuse. You have the fiduciary responsibility to make sure that things happen correctly.
The fiduciary responsibilities, include investing. Obviously, you don't want to have $100,000 just sitting in a checking account. For that $100,000 to grow, maybe you want to invest it, responsibly with stocks, bonds, so that money will continue on longer than, maybe a couple of years. So how do you invest? Well, what George already discussed was, delegating that responsibility to an investment advisor. You want to make sure that investments are diversified. Ohio has the Ohio Prudent Investor Rule that just basically says, well, what would a reasonable person invest this money with? You don't want to invest it all in Tesla stock, because that might disappear within a day, as the market's shown recently. So you want to diversify with different types of stocks, different types of accounts. A trust, what a lot of clients misunderstand initially is, as a trust is just as a person, a trust can open many different bank accounts, a checking, a savings, a mutual fund, a CD. So you're not just pigeonholed to one or two accounts. You can have multiple accounts under the trust name. Then there's reporting requirements. According to reporting requirements are all at least annually of accountings to beneficiaries. But it all depends on what the trust really says. Sometimes the trust might say there is no reporting requirements. But Ohio law says, hey, at least annually. That might be statements, it might be tax returns, and extraordinary trustee compensation. If the trust is managed or overseen by the probate court, well, then you'll have annual or biannual accountings. Every court is different. Every county's court is different. Then you have to ask the court for applications for authority to expend. If the trustee is managed by a court, you have to ask the court for permission to use funds prior to using the funds. And then there might be reporting to benefit agencies, like Job and Family Services, who oversees Medicaid, or Social Security if that beneficiary is on SSI. we just wanted to share, this sample court fee schedule. Every court is different on how they calculate fees for trusts, and a lot of, even though the trust might not be court administered or court overseen, a lot of provisions in trust says, well, what is a reasonable compensation of the local probate court allow? And here's an example. Well, it's the $12 per the first thousand for the first $1 million that's in the trust. And they also calculate, distributions and income that's coming into the trust. So it goes through this whole formula. Here's just a very basic court fee schedule that one court might allow.
So there's special challenges.
There's special challenges when you're administering a special needs trust. Obviously, your beneficiary is likely to have diminished capacity, is going to need social services, is going to need public benefits, and so there is quite a bit of baggage that goes along with that. So for many public benefits, the state is a creditor. So for example, in Medicaid benefits, if a person is over 55 or in a long-term care situation, Medicaid benefits paid out are collectible after that person passes away. And the trust may or may not be subject to that, depending on a lot of circumstances, but that is a factor. The beneficiary might have need for quite a bit of income to come their way. If they're in a long-term care situation, they may need quite a bit. They may not. So the trust itself may not have a way of dispersing the assets in the investments as they grow. So that can present its own challenges. And then, as Ethan alluded to, there's always a possible involvement of the court. Many special needs trusts are created for the benefit of somebody who is under a court-imposed guardianship. And if that's the case, then the court's going to be involved in what is going on for the benefit of that person. So one of the important things that you'll have to keep in mind when you are managing a special needs trust is figuring out exactly what benefits public benefits the beneficiary has or could get. So it could be things like SSI, Medicaid benefits, potentially Social Security disability benefits, and then figuring out how to get those benefits and keep them while being able to use the trust for the beneficiary's benefit as well. So speaking with an elder law attorney or a special needs attorney can really benefit you and give you guidance on that. And then there's the whole aspect of what is the best care situation for this beneficiary. Maybe being in a institution or a long-term care facility might not be necessary. Maybe they could be in a group home. Maybe they could potentially live on their own, depending, and with just some oversight and checking in. So getting professional assistance with figuring that out is beneficial as well. And then there's just sort of nuts and bolts things like securing the services, getting some of that equipment like a wheelchair or a chair or a stair lift. And then there's also dealing with all of the other people in that beneficiary's life, family members, friends, caretakers. There's more to the beneficiary situation than just the beneficiary and the trust. So there's a lot of family dynamics that can happen as well. And one of the things that you can always look to, or hopefully can look to, is a letter of intent. So the creator of a special needs trust for the benefit of somebody else may draft a letter saying, this is what I want this trust to be used for. This is the purpose that I want this trust to be used for. And you can use that as your lodestar, as your guiding point to, all right, I have a choice here. What is the intent of this trust, and what is it that I should do to fulfill that intent? So if your beneficiary is likely getting public benefits that are means tested, such as Medicaid and SSI, you have to be very careful with the way you disperse funds from the trust. In general, you shouldn't make any distributions directly to the beneficiary. Once assets or resources come into that beneficiary's hands, they are countable for public benefits purposes and can interfere or even cause them to lose those benefits. You can pay directly the providers of any goods and services. So you can have a provider give you an invoice, or you can go out and purchase something directly, and that's okay. And then an important rule is you don't want to pay for any food and shelter, particularly for SSI recipients. SSI will diminish benefits if somebody is receiving food and shelter from another source. So you want to make sure that you're not using trust funds directly for those sorts of things. And in general, these aren't necessarily absolute rules. There's a lot of nuances and ins and outs with everything. But in general, you should keep this in mind unless somebody who is knowledgeable, like an attorney, tells you otherwise. And so as far as the residence, so for many parents who have a special needs child, they may intend and want their child to remain in their home for as long as possible. And a lot of times when the child is a minor or very young, and the parents are active and able to handle things, it's a good situation. But you may be in a situation now where mom or dad has passed away or has stepped back. The beneficiary is a little older, and so it presents some issues. Who are the care providers? Does this beneficiary live with any roommates? Can the beneficiary continue to afford to live in the house with the benefits and the income that he or she has, plus what the trust is able to do? And then there's a whole another issue with insurance. Now that a person with special needs lives in this home, the ownership situation may be changed. Does the insurance picture change? And then particularly vehicles. And vehicles they present particular challenges. In general, you want anything that the beneficiary is using to be titled in the name of the trust. But the problem with vehicles is that they go out and they get in accidents and they are subject to lawsuits. So if a vehicle is titled in trust and is involved in an accident, the trust is liable if the driver is at fault. So anything in that trust could potentially be reachable in a lawsuit, particularly in situations where the beneficiary may not have a lot of resources, but the trust might. So it's better for if the beneficiary is going to have a vehicle, to title it in the individual's name, but the trust would have a lien against that vehicle, so that vehicle wouldn't have any value as far as the beneficiary is concerned. Then also insurance. If your trustee is or another family member is that primary caregiver, you might want to take out a life insurance policy on that person, because if they were to get in an accident and pass away, replacing them could require hiring a professional, and you would want to have the additional resources there in place. And as far as prepaying for funeral arrangements, we always think this is a good idea. It's something that you need. Most public benefits programs encourage it and allow it, so there's no reason not to.
So, taxation of trust. this is always an exciting topic. It's obviously it's necessary. The way that trusts are taxed is just a little bit different than a typical person. The two types of trusts that we that are mainly come to mind are, self-settled trusts, or special needs trusts, and third-party trusts. So a self-settled trust is, a grantor trust for tax purposes. So that means that the trust holds the property owned by the beneficiary. That's what a first-party special needs trust is. In order for the beneficiary to retain Medicaid and Ssi benefits, they transfer it to a special needs trust. That was their assets that they're transferring to the trust. You can use the beneficiary Social Security number. We always recommend getting an employer identification number or an EIN. Just to make sure that everything is separate from the beneficiary. So logistically, the trust would file a tax return, and any income that the trust makes, from mutual funds, from interest income, from if the trust owns real estate and is renting out a property, and that income coming to the trust, then that's all pushed out to the beneficiary in a K-1. And the reason for that is the trust has unfavorable tax rates compared to the beneficiary. So the beneficiary will save taxes using this approach when the income is pushed to the beneficiary, and the beneficiary then reports that income on his or her individual tax return. This creates a problem, or not a problem, but an issue with caseworkers. George, if you go to the next slide. That's the difference between taxable income and beneficiary income. Taxable income does not interfere with public benefits eligibility. But that's the reason why the trustee retains, receipts, statements, is to prove that this income reported on the beneficiary's individual tax return is not beneficiary income. It's taxable income for tax purposes only. Then the taxation of third-party trusts, a little bit different than first-party special needs trust. So the third-party trusts, what we call wholly discretionary trusts. It's a third-party trust is, and we'll get into the difference, the nuances of each trust later. But for tax purposes, the third-party trust will have a separate EIN. It's classified as a complex trust according to IRS rules. And it may be a qualified disability trust. Most likely it will be. To be a qualified disability trust, there's certain things that need to be checked off the list. If the person is disabled for Social Security purposes, and is this a sole benefit trust with wholly discretionary provisions? With this trust, though, the distributed income is pushed out to the beneficiary. The undistributed income is taxed with the current trust law tax rates. So third-party trusts, have an unfavorable tax position. But if it has a qualified disability trust designation, that will greatly reduce the tax consequences for that trust. And what we're not a tax firm. We know the basics of trust tax law. We always refer our clients to CPAs that know what they're doing in order to reduce the tax consequences for these trusts.
So in addition to being responsible for the financial side of the trust management, the trustee is also responsible for the care needs of the beneficiary. So if the trustee themselves is competent and knowledgeable and feels that they can manage the care of the beneficiary, they can certainly do so. If not, they can hire a professional care manager, act as their eyes and ears. Particularly if the trustee doesn't live in town or lives in a different state, or just simply doesn't have the knowledge about how to deal with the types of services and benefits and placement and what have you, a professional care manager can act on behalf of the trustee and advise the trustee so that they can get the best possible care for the beneficiary. And the way you want to think about it is the care manager, whether that's the trustee or a professional, fulfills the role that prior to the parent stepping back or stepping away, that they carried out. They were the ones who got searched for, obtained benefits for their child, arranged for their care, made sure that they got them in the best possible situation. So if you do hire a professional care manager, they are a health and human services specialist, and they help families access care. And their experience is usually with getting care for older relatives or individuals with disabilities. And they're going to act as your guide and your advocate. So they're going to be able to identify problems, offer solutions, but they're going to really encourage you and to make the final decisions about things. That you're the one that knows the beneficiary best. They're likely one of your family members. You've known them for years. So they're going to want to defer to you as much as possible, because ultimately you're the one who is fulfilling the intent of the settlor of the trust. So care managers, they will also assist and help with government benefits, public benefits. They will make recommendations about what might be an appropriate disbursement from the trust. They'll visit the beneficiary, make sure that there's no issues, and if there are issues, bring them to your attention. They're knowledgeable about the facilities and providers out there, so they can recommend who to go to, who to avoid, and they have the knowledge and training to evaluate whether what's going on is quality and whether it is appropriate in terms of placement, services, providers. What they'll do is they'll provide a care plan where they'll say, okay, over the next year, this is what the care should look like, and here's how I recommend you go about getting it. And you can use that to guide you when you are moving forward and seeking out the care for the beneficiary. And our firm has a professional care manager on staff. Her name is Janelle Leonard, and she is available. We have a care managing service that we provide. So any trustee or new successor trustee can talk to her, look to her for help with that care management. And the important thing to know is you can use those trust resources to pay for these services. And that goes for any of the outside professionals that you would hire to help you with this trust, that you can use trust resources for those professionals. You don't have to pay it out of your own pocket.
So I'm gonna, speed through these next slides, just so we can stay on time here. Obviously, when you're dealing with receiving benefits from SSI or Medicaid, especially, there's a lot of reporting requirements that the beneficiary needs to make. And, if they are a beneficiary of a special needs trust or wholly discretionary trust, then the trust has to make these distribution or these reportings to them as well. So you need to report, when the trust is funded, when countable distributions are made, when full accounting, when they request Social Security or Medicaid is saying, hey, we need an accounting of this trust to make sure that you are managing this trust appropriately for the beneficiary. Well, you have to provide that, or they'll could potentially stop benefits. When the beneficiary shows income on the tax return, there's, if there's a question of whether you have to report something, it's always best to report it. You want to give them more information than less information. These are especially important to report to Social Security within 10 days if the beneficiary has moved, if sorry about that. If there is a change in any countable resources, there is new eligibility for other public benefits, or a change in the income. That's all that needs to be reported within 10 days to Social Security. If they're on SSI, then there is more reporting. Medical improvements that the beneficiary is no longer considered disabled, the beneficiary is married, the beneficiary had a major medical event, and if there was any unintended trip outside the United States. I just saw a question pop up, about SSI and Ssdi. There's more reporting requirements for SSI because SSI is a needs-based program. Ssdi is Social Security disability insurance, where there's less reporting requirements. So SSI, there's always going to be more reporting because they want to make sure that, number one, this person is disabled, and number two, that this person is well below the poverty level of meeting those needs-based requirements. Then if there is a denial of benefits, whether with Social Security or Medicaid, there's always an appeal process. The beneficiary always has due process rights, and that means the beneficiary will receive a notice that they will stop losing benefits on such and such day, and that you have the right to appeal within a certain number of days. And the notice should state how long you have to appeal. If you don't appeal, then benefits will stop and you'll have to reapply. Then there's a periodic update and review, just internally, that the trustee should make. And this is also for the settlor that has created the trust. If the settlor is still alive, well, you just need to, if something major has happened in that life, or there has been a major change in the law, that the trustee or the settlor or both just need to be on top of things and make sure that does our situation that was 10 years ago match the situation today.
Okay, we'll get into the specific benefits now a little bit. So first, we're going to talk about disability benefits, and the definition that the Social Security Administration uses, that then all the other public benefit administrations use as well. I won't get into the nitty-gritty details here, but the gist of it is that there has to be an impairment that's long-term or permanent, and it prevents that individual from doing what's called substantial gainful activity. And essentially, are they able to work and earn more than in 2021 $1,310 a month? So that's sort of the criteria that they use to determine whether somebody is quote unquote disabled. There's a lot of nuances to it, and different programs have different wrinkles, but that's sort of the core of it. There is whatever is impairing the individual, making it so that they cannot have substantial gainful activity. Can they not earn enough income because of their impairment? So for Ssdi, that's the Social Security Disability Insurance, and Medicare, this is not means tested per se. Again, there is that substantial gainful activity consideration, but otherwise they're not going to look at how much assets the person has, how much money is in their bank account, whether they own a home or anything like that. They simply have to meet that definition of disability and it has to be determined that it's going to be continuing for at least a year or permanently. So 5 months after the Social Security Administration determines that that person's disabled, they'll start receiving their benefits. They will then be eligible for Medicare 2 years after they get that first payment. So, and this is the important thing, and I'll digress from here for just a second, because it's important to point out. While somebody is on Ssdi, but before they qualify for Medicare, look to see if their income is low enough that they will qualify for Medicaid. In recent years, most states have expanded Medicaid to include any individual who makes less than 138% of poverty level. And so this is going to include most Ssdi beneficiaries who aren't on Medicare yet. So it's important you can get health coverage for that person before those Medicare benefits kick in by applying for Medicaid and getting that modified adjusted gross income, MAGI, benefit put in place. And again, MAGI is not going to have any sort of resource requirement either. So if they qualify for Ssdi, it's likely they will also qualify for MAGI until they get that Medicare. So Ssdi, the amount that they get is dependent on their prior earnings and payment of Social Security taxes. It's similar to how Social Security itself works. You know, you have to work enough covered quarters to get a certain level of benefit. So there's a lot of wrinkles to that, but essentially that's how the benefit will work. Now, childhood disability benefits for somebody who has been disabled since before age 22, and their parent now is retired or disabled themselves or has passed away, they can get disability benefits even into adulthood that aren't means tested. Again, that gainful activity standard is relevant. So if their condition has improved to the point where they're now able to earn more than that 1,310 amount for this year, they may not be able to continue getting those benefits. Now, SSI and Medicaid are a little different. They are means tested. So they will not only look to see whether you meet the disability criteria or the health condition criteria, but then they're also going to look at your financial resources. So I alluded earlier, I talked about how the modified adjusted gross income, the expansion Medicaid, that doesn't have a resource requirement. You can own as much as you have, but it will have an income requirement. So if you make more than that 138% of federal poverty level, you won't be able to get Medicaid benefits unless you meet another category of Medicaid. SSI, again, you have to be disabled, and then they will also look at your countable resources. So for an individual, that's $2,000, and income of less than, I believe it's about $794, I believe, this year. So you have to apply for that. This is where you have to then document and show all of your income and assets. Both Medicaid, both SSI and long-term care Medicaid both have a look-back period where if you've transferred assets away prior to applying for a certain period of time, you may not be able to get benefits or may have reduced benefits because of that.
The presentation. So we're gonna cover everything, but we're gonna go a little bit quicker here so we can cover everything. There's income and resources, they're treated differently. For Medicaid and Social Security. But this is for Social Security. Receipt of an asset is income in the month received, and you have a 10-day reporting requirement. An example of this is the SSI beneficiary just received an inheritance of $10,000 from a life insurance policy, and the life insurance policy, in and of itself, that's not income. But for Social Security purposes, for SSI purposes, that is income that month. If it's still owned by that individual, then it's at the end of that month, then it becomes an asset, and then it becomes a resource. So there's when that person receives that money, there's a lot of things that need to happen right away. We need to get that asset out of that SSI recipient's hands in order to keep the benefits. For income for an SSI recipient, there are a lot of rules regarding it. I mean, when a person's on SSI, there's so many reporting requirements. You have to give them the person's wages, W-2s, pay stubs almost every month and at least annually. But this is how they determine if this person works or is receiving income from another source along with their SSI. They follow these rules. These are the main rules. There's a lot of rules involved, but they disregard the first $20 of unearned income. So that, that inheritance that they received, or, a payment that they received from mom, they disregard that first $20. For earned income, so they're working, they disregard the first $65 a month plus 1/2 of the earned income. And then there's impairment related work expenses that they won't count. There's deeming. I'll get into deeming in a little bit, but mom and dad's income, if it's a minor child, deems to that child. In-kind support and maintenance. This is where the food and shelter rules come into place, that if the SSI beneficiary is receiving food and shelter from another source, from a trust, from mom and dad, from another person, then their SSI benefit will be reduced. And there's a Medicaid, the spend down rules apply as well. Then we have resources for SSI purposes. it has to be owned by the individual, so it has to be titled to that person and available to that individual, and not exempt. So there's exempt resources, and I briefly talked about the car of any value, a house. I think the house value is, up to $550,000. So it's, and then there's prepaid funeral plans. There's other smaller exempt resources. The deeming, this, like I said, this really applies to, this is why minor children aren't receiving SSI, is because mom and dad's income, mom and dad's assets deem to the minor child. So the minor child doesn't qualify. Once that child turns 18, then mom and dad's assets and income does not deem. So that's why at age 18, they qualify for SSI.
So just getting into a little more detail about exempt resource. So your household goods, the stuff in your house is not countable resource. Your home, so long as it is your primary place of residence, is not counted. One vehicle of any value, an irrevocable funeral contract, and burial plot, life insurance. If all of the life insurance policies that you own together have less than a total face value of $2,000, then they are not countable. If you have multiple life insurance policies, but they together add up to more than $2,000, even though each individual one is less, then they're still countable. The back payments of Social Security for 9 months after they are received, Medicaid will exempt them for 6 months. The trusts that we have been talking about, special needs trust and wholly discretionary trusts, and there's another kind of trust called a pooled trust that functions very similarly to a special needs trust, but is managed by a third-party nonprofit. All these trusts that we've been talking about, if they're drafted correctly, are not countable resources either. So for SSI, we talked about this briefly earlier. It's an income program for individuals who have a disability, who don't have Social Security coverage. The intent is to pay for basic needs, food and shelter. It's administered by the Social Security Administration. It is means tested. You have to have less than, an individual has to have less than $2,000 in countable resources. A married couple has to have less than $3,000. The income threshold is low. Again, in 2021, $794 for a single individual. I don't have the number right in front of me, but it's $1,100 something if a married couple are both qualifying for SSI. This last bit, a representative payee. So a lot of times an individual's disability makes it so that they don't have the capacity to handle their own financial affairs. So in that case, a person steps in to receive their benefits. They are the representative payee. They have to get approval from the Social Security Administration to be a representative payee. They can't just be named as an agent or a trustee or any sort of private agreement like that. Social Security has to approve a person to be a representative payee. Medicaid is the major medical coverage for individuals who don't have the resources to pay for it themselves. So basic Medicaid provides health insurance. There are programs for at-home care, home health aides. There is prescription drug coverage unless they are on a Medicare plan. It will pay for some durable medical equipment. The Medicaid program in Ohio at the state level has the Department of Medicaid, which oversees the whole program, but the applications of each individual and the cases of each individual are handled at the county level. through the Office of Job and Family Services. Medicaid is means tested in Ohio, follows the Social Security rules. So what goes for SSI goes for Medicaid, less than $2,000 for a single individual, $3,000 for a married couple that are applying together. Income of less than, for somebody who's on disability, income of less than $794 a month in 2021. Again, there is that expansion Medicaid for individuals who qualify for it that has a higher income threshold. And there's also then the long-term care Medicaid benefits that have a lot of additional provisions for folks who need long-term care. So the Medicaid waivers are parts of the state plan that are approved to deviate from the standard Medicaid plan that's laid out at the federal level. In Ohio, a number of the ones that we have are individual options, level 1, the home care waiver, the assisted living waiver, and passport. Just real briefly, I actually had the individual options I think should be struck because I believe that's not actually was done away with. But level 1 is for somebody who has intellectual disabilities or severe developmental disabilities that will pay for the kind of care that they need. The Ohio home care waiver is for somebody who meets a certain threshold of care and needs help at home. And I'll skip ahead to passport is essentially the same program. Home care is for individuals who are age 60 and younger. Passport is for individuals who are 60 and older. And then the assisted living waiver is a way of getting assisted living paid for through the Medicaid program instead of nursing home Medicaid. And I could talk about that for another hour. So the upshot of assisted living waiver is some assisted livings will take it, and most will require that the person be there for a period of time in private paying before they will allow them to start using assisted living waiver as a benefit. Excuse me. For these, just real quick, the income limit for these long-term care type programs is 300% of the SSI level, so you can have quite a bit more income. So that's $2,382 a month in 2021. And actually, even if your income is higher than that, you can use what's called a qualifying income trust to still get meet income eligibility. So essentially, there's no income limit. If you have above that 2382 level, you have to just take some extra steps in order to qualify.
Yeah, just to clarify what George said, the IO waiver is still in effect. It's just the wait list was dramatically changed. So that it's more of a a needs-based opportunity for the DD population, the developmental disability population, and the IO waiver and the level 1 waiver, those are administered by the county DD boards, the developmental disability boards. The other program, the Medicaid buy-in for workers with disabilities. This is for people that are on Medicaid and they are working. Well, this program allows the Medicaid recipients to earn more money and to have more assets on hand. So, the government is saying, we understand that you have a disability, but, and because when we want you to work, we want you to be an active member of, of society. So we're going to relax these rules of the $2,000 limit and the income limit, so you can work and you can have a little bit more money in the bank. So this is what the MBIWD, that's a mouthful, but that's what this program allows for. The food and shelter rules, I talked about it a little bit, but I wanted to give you an example here. So this is direct payment from a third party to an SSI recipient, and their SSI will be reduced by at least 1/3. So, or not at least 1/3, by 1/3. So an example of this is that we see all the time is 18, well, if you go back, George, the child who is 18, still living at home, just started receiving SSI, and because he lives at home, he's receiving free food and shelter from mom and dad. Mom and dad pay for, you know, all of his food, all of his rental expenses, and so his SSI is reduced by 1/3. He's not receiving the $794, he's receiving $520. And the way we get around that is we do a room and board agreement between mom and dad and the SSI recipient, and that will, so child will pay rent to mom and dad and receive the full SSI. Mom and dad can has this money they can set aside for the son, or if they have the need to pay expenses, then they use those expenses. We provided some case examples. Let's just move past that since we're running a little behind. You can read those, and if you have any specific questions about it, you can ask us later. Why don't you go ahead, George?
Okay, so this is sort of a typical example. A person who has developmental disability turns 18. They are now eligible in their own right for a lot of public benefits, but there's a lot of changes then that happen. So one of the most important is that the parents are now no longer the legal decision makers for that child. So the question is, can that child who is now an adult make those decisions for themselves? And some individuals with developmental disabilities are able to do that, but many aren't. So the question is, what kind of authority is appropriate? The most comprehensive authority is guardianship. That is where the court appoints a person to exercise the legal rights of another. It's a pretty severe type of situation. The person is under the guardian is under the supervision of the court, has a lot of reporting requirements. So potentially there could be an alternative if the individual needs somebody to have authority to make decisions on their behalf. They could sign power of attorney. There could be other less restrictive alternatives as well. So this is when the providing food and shelter by a parent to their now adult child becomes categorized as under an income. So this is where you want to think about what makes sense as far as arrangements, so that SSI Medicaid benefits aren't interfered with. This is where that room and board agreement is helpful, even if the child is still living at home with you. Formalizing some room and board agreement can protect benefits from being reduced. So then for an adult, a lot of what happens is the parent then retires, and this is what Ethan was talking about earlier. The child then begins to receive half of the parent's retirement benefit in lieu of their prior Social Security or the SSI benefit, the net effect is they're in a better situation. They get more income, they're eligible for more benefits. The patient when the parent passes away, that child starts to receive 3/4 of the parent's benefits. So again, even more. And with all of this comes that Medicare eligibility, because now they're in the Ssdi system instead of the SSI system.
And just to piggyback off of that, I saw a question that directly pertained to that from Larry, or not Larry. Where did I see this? From Tom. Tom said about this 3/4 of the Social Security that he'll be on SSI or Ssdi then. And this puts him over the SSI and Medicaid limit. Does he lose Medicaid? No, he won't lose Medicaid, because this is an exception to that rule. If he is receiving Ssdi based off of in this DAC program, the Disabled Adult Child Program, then he will continue to have Medicaid. Medicare will become his primary, and Medicaid will be his secondary. Okay, so back to the slide here. So these are the tools that we specialize in to ensure that beneficiaries are keeping their benefits. There's two types of, generally speaking, there's two types of trust. There's the third-party trust that is set up by the parent or other person. It doesn't need to be a parent, doesn't need to be a relative. I could set up a trust for a disabled individual, and we could, as long as that money doesn't is owned by that disabled individual, then that's a valid third-party trust. Then there's a self-settled or first-party trust. It's also called, if you've done research, a D4A trust. That's from the federal statute, D4A. The self-settled or first-party trusts have a Medicaid payback provision, and for the most part, these trusts are administered the same, except for small tax changes between the two trusts. Administratively, disbursements, reporting, it's all the same. Third-party trusts, it's codified in the revised code. They're 5163.21. It's like I said, it's never funded with assets belonging to the disabled beneficiary. So mom and dad set up a trust. They fund those assets at death directly to the trust. It doesn't go to the beneficiary and then to the third-party trust. It goes straight to the trust. So yes, the beneficiary is the beneficiary of the trust, but he never had ownership or never will have ownership of those funds. It's available if, as a resource, if the trustee can spend for, if the trust specifically says that the trustee can spend money on these certain things, like medical care, health, welfare, general well-being, then Medicaid and SSI will say, hey, this is accountable resource to the beneficiary. He can demand a distribution. So these trusts are wholly discretionary. The trustee has the discretion to use these funds or not use these funds. So then the self-settled or self-titled trusts, that is through the U.S. Code section D4A. It's used for funds which a disabled person owned that they received from an inheritance, litigation, child support. The disabled beneficiary, if their parents are divorced and they're receiving child support payments, that is payments to that beneficiary. And of course, improperly drafted third-party trusts, that would be classified as a special needs trust then. So the Medicaid Payback Trust, that first party trust, it's established by the parent, grandparent, guardian, or the court. And recently, the beneficiary is able to establish a special needs trust as well, as long as they're under the age of 65. And it has to have this payback provision to the state upon the beneficiary's death.
So we talked about this briefly before, but this is the ABLE Act. The idea here is to allow an individual to have, a disabled individual to have some additional discretionary assets that can be used for their benefit without running afoul of the resource and means testing rules. So this came into effect back in 2014. The states themselves set up their own programs. In Ohio, it came into effect in 2015. Ohio calls them the stable accounts, but that's just what Ohio calls them. That's the same as an ABLE account. The thing about the ABLE account is that the beneficiary has to have been disabled prior to age 26. Initially, they wanted it to make it of any age, but by the time the bill got through Congress, it had this age restriction. A person can only have one ABLE account. The interesting tidbit is the beneficiary doesn't have to reside in the state where that ABLE account is opened. So if another state has more beneficial rules for its ABLE stable accounts, you could take advantage of that. The same standard that we talked about earlier, that substantial gainful activity standard. The accounts can be opened by the beneficiary themselves or their parent, their guardian, somebody acting on their behalf as a power of attorney. And I think this was you, Ethan. Yeah. Sorry, I ran through that quick.
So the contributions to the stable account, that is any person can contribute to the stable account. And person, it doesn't mean a human being. It can mean any list of trusts, estates, partnerships, companies. A change in the beneficiary is allowed for siblings, and you can roll over from an ABLE account from a 529 account or between family members. So one thing that I see often is parents establish a 529 account for the education of the beneficiary, and then they realize, well, he's never going to go to college. What are we going to do with this money in this account? Well, you can roll the 529 account over to an ABLE account. That way, the money is protected for benefits, and it's still designated for that individual. So how much can you contribute to a stable account? It's $15,000 per year. The total balance it's a little more now. We forgot to update the new limit, but it's a lot of. It's over $462,000. However, we'll get next slide. We'll get into the there's limitations for SSI. That is, if it exceeds $100,000, the account, then it starts counting towards the $2,000 limit that SSI and Medicaid that have. There is a Medicaid payback provision for a stable account, so it works like a special needs trust, a first party special needs trust, but it's only Medicaid payback to the date that they establish the account. So it's not a Medicaid payback before the establishment of the account. That's you, George.
So there are some restrictions on what the money in the able or stable account can be used for. These are expenses that are related to the beneficiary's disability and are for that beneficiary's benefit and are for maintaining or improving their health, independence, or quality of life. So what does that mean? Well, here's sort of a list of things that generally will meet that criteria. Education, housing, transportation, employment, any sort of technology to assist them and the services that go along with that. Anything for their health and wellness. Financial assistance, management and administration, legal fees. So if they, if they need assistance with any sort of legal matters, the expenses of the ABLE account itself and any oversight or monitoring of it, funeral and burial expenses, and your kind of catch-all basic living expenses. So this is this encompasses quite a bit, and it's pretty broad. So it's generally, if for small amounts of money that you are going to make available to a beneficiary to use at their discretion, most of the things that they're going to want to use it for will likely qualify. If it's something that is a little odd or out of the blue, you might want to talk to an expert before letting the individual use those expenses.